Aloha, my name is Hope Kauai. This is a summary of a workshop that was presented on August 16, 2014 in Kilauea, Kauai on preserving public access on ancient Hawaiian trails. This presentation will cover a summary of the workshop, pertinent Hawaii state statutes and laws, and provide contact information for agencies, legislators, and public hike and trail groups. In summary, there are at least 3 potential methods for securing public access on ancient trails, and one is by historic or customary use as determined by law, the other is implied dedication, and the third is public trust doctrine. And the public trust doctrine states that all public lands and interests are held in trust by the state. We're focusing on the Alaloa, but there are many different kinds of ala. Ala haki, ala hele, ala hula, ala kahakai, kahavai, ala kai. Our first presenter, Dr. Richard Stevens, taught us how messages come to us from ancient trails through beauty, mystery, magic, mana, importance, and connections, and the importance of preservation and restoration of our ancient trails. Tom Pierce focused on the wealth of Hawaiian trail law, starting with the 1797 Law of the Splintered Paddle, the 1839 Hawaii Bill of Rights, 1840 Hawaii Constitution, 1848 Mahele, 1850 Kuleana Act, which has become HRS 7-1, and the 1892 Highways Act, which is now further codified into HRS 264-1. The Hawaii State Constitution, Article 1, Articles 9 and 10, and Article 12 also talk about public trust access. When a private party is permitted to take or diminish a public trust asset, it constitutes a breach of public trust. When the state of Hawaii fails to compel access, it has breached its obligation to the public. So public trails are determined by maps, mo'olelo, mele, stories, and documents. And the maps can be registered maps, plat maps, file plans, TMK maps, plantation maps, mission maps, Bible maps. The mo'olelo can be written, it can be oral, it can be traditional, it can be on kapa. The documents, the land court awards, kuleana, and grants are all available. Most all are available online. Any trail on a map before 1848 in Hawaii is considered a public trail, because before 1848 all land was public. Any trails on a map that were public at 1892, when Queen Liliuokalani signed the Highways Act, are public in perpetuity. Any public road, trail, or bridge that was established after 1892 is a public trail in perpetuity. And under certain conditions, continual use can establish a public trail. Alan Murakami from the Native Hawaiian Legal Corporation explained to us how every public agency has a responsibility before issuing permits to identify any traditional and customary practices, assess the impact of this permit to those cultural practices, and to reasonably protect those resources, traditions, and practices. The state has a policy to protect those rights traditionally and culturally exercised for religious, subsistence, and cultural purposes. And the ongoing continual use of gathering limu kohu is a traditional use. We welcome Mary Jane Naone, State Historic Archaeologist for the Historic Preservation Division, to Kauai. We certainly are eager to have her work with us on state historic trails. Debbie Chang focused on how to hold the state and county accountable for ancient Hawaiian trail protection, and suggested that it's very important to educate yourself as best you can. Knowledge is power. Know your facts and be prepared for the long haul. Network, develop a teamwork so you don't get burnt out, so you can depend on other people and communicate effectively. Work with your agencies, develop friendships and relationships with the people in the agencies, because you will be working with them for years. Dennis Kaua'i Hart talked to us about how taking care of trails is his kuleana, given to him by his mother, and it's his job to watch out for the trails, to clean them, to malama them wherever and whenever he can. He also didn't scold me, but he corrected me on one of the spellings on one of my slides, and I so totally honor that. I had used a Kauai spelling for ahuhu, and I knew there's other ways to spell it and pronounce it, but I used the Kauai spelling. These gentlemen are Dennis's great-grandfather and great-uncles, and they are on Hawaii Island picking auhuhu on their island. I will call it auhuhu. I totally stand corrected, and I honor that correction from him. He is malamaing the trail, the knowledge, and the importance of this cultural practice. Lucienne de Naie talked about kingdom roads and trails on Maui and how her community maintains them, and the importance of especially kupuna testimony and early public works documents. With informed citizens, good trail mapping and research, combined with diligence and support offered to agencies, solid relationships with agencies will be formed, so we will have a legacy of trails available for the public to use in the future. That's a mighty powerful statement. Eric Burton talked to us about how he locates trails by mapping cultural indicator plants, especially bananas. Kalo ki kukui ni'u, but especially bananas. Teddy Blake from Kilauea brought to the workshop knowledge about development crisis and the impact to trails, and how the state or the county not stepping up to the plate is allowing these trails to be damaged. My program on the Alaloa o Manokalanipo featured the ancient Lateral coastal trail that circumnavigates the entire island of Kauai. It is documented by ancient archaeological sites, proto-contact agricultural features, and modern infrastructure and development. The use of this trail is continual. This section focuses on pertinent Hawaii state statutes with regards to trails. The Hawaii State Constitution, Article 11, Section 1, states, "For the benefit of present and future generations, the state and its political subdivisions shall conserve and protect Hawaii's natural beauty and all the natural resources, including land, water, air, minerals, and energy sources, and shall promote the development and utilization of these resources in a manner consistent with their conservation and in furtherance of the self-sufficiency of the state." And ending with, "All public natural resources are held in trust by the state for the benefit of the people." Article 11, Section 1 further continues that the public trust duties imposed on the state shall also be applied to the county as a political subdivision of the state, that the county also has an obligation to conserve and protect the state's natural resources. Hawaii State Constitution, Article 11, Section 9 states, "Every person has the right to a clean and healthful environment, as defined by laws relating to environmental quality, including the control of pollution and conservation, protection, and enhancement of natural resources." Article 12, Section 7, Traditional and Customary Rights. "The state reaffirms and shall protect all rights customarily and traditionally exercised for subsistence, cultural and religious purposes, and possessed by ahupua'a tenants who are descendants of native Hawaiians who inhabited the Hawaiian Islands prior to 1778, subject to the right of the state to regulate such rights." So I'll say that again. Section 7. "The state reaffirms and shall protect all rights customarily and traditionally exercised for subsistence, cultural, and religious purposes." Hawaii Revised Statute, HRS 1-1. Adopts the common law of England, except as otherwise expressly provided by the Constitution or laws of the United States or laws of the state of Hawaii or established by Hawaiian usage. HRS 7-1 states, "Where the landlords have attained or may hereafter obtain allodial titles to their lands, the people on each of their lands shall not be deprived of the right to take firewood, house timber, aho cord, thatch, or kili from the land of which they live for their own private purposes, but they shall not have a right to take such articles to sell for profit. These people shall also have a right to drinking water, running water, and the right of way. The springs of water, running water, and roads shall be free to all, and all lands granted in fee simple, provided that this shall not be applicable to wells and watercourses which individuals have made for their own use." HRS 46-6.5 is the subdivision law concerning public access, and it specifies how each county shall adopt ordinances which shall require a subdivider or developer to establish public access from a public highway or a public street to the land below the high water mark on any coastal shoreline, and to dedicate land for public access by right-of-way from a public highway to areas in the mountain where there are existing facilities for hiking, hunting, fruit picking, tea leaf sliding, and other recreational purposes. Our Kauai Ordinance 777 specifies the distance that these trails shall be dedicated. Not more than 1,500 feet. Anytime you develop more than 6 properties in a subdivision. HRS 173A-5 sets aside monies to acquire land for access and preservation purposes. The resource values are watershed protection, coastal areas, beaches, ocean access, habitat protection, cultural and historic sites, recreational and public hunting areas, parks, natural areas, agricultural production, open spaces, and scenic resources. HRS 115, public access to coastal and inland recreation areas. HRS 115-1, the Legislature finds that miles of shorelines, waters, and inland recreation areas under the jurisdiction of the state are inaccessible to the public due to the absence of public rights-of-way. That the absence of these public rights-of-way is a contributing factor to mounting acts of hostility against private shoreline properties and properties bordering inland recreational areas. That the population of the islands is increasing while presently accessible beach, shoreline, and inland recreational areas remain fixed. That the absence of public access to Hawaii's shoreline and inland recreational areas constitutes an infringement upon the fundamental right of free movement in public space and access to and use of coastal and inland recreation areas. The purpose of this chapter, HRS 115-1, is to guarantee the right of access to the sea, shorelines, and inland recreation areas and transit along the shorelines, and to provide for the acquisition of land for the purchase and maintenance of public rights-of-way and public transit corridors. HRS 115-2, public access to coastal and inland recreation areas, acquisition of lands for public rights-of-way and public corridors. When the provisions of Section 46-6.5 are not applicable, various counties shall purchase land for public rights-of-way to the shoreline, the sea, and inland recreation areas, and for public transit corridors where topography is such that safe transit does not exist. It says the counties shall purchase land for public rights-of-way. HRS 115-3, criteria for public rights-of-way. A distance at reasonable intervals, taking into consideration the topography and physical characteristics of the land the public is desirous of reaching, is established as the maximum between public rights-of-way for the purpose of this chapter. HRS 115-4, the right of transit along the shoreline. The right of access to Hawaii's shoreline includes the right of transit along the shorelines. HRS 115-5, the beach transit corridor defined. The right of transit shall exist seaward of the shoreline, and this area shall be defined as a beach transit corridor. Okay. However, in areas of cliffs or areas where the nature of the topography is such that there is no reasonably safe transit for the public along the shoreline below the private property lines, the counties, by condemnation, may establish along the Makai boundaries of the property lines public transit corridors which shall be not less than 6 feet wide. This used to say shall be established, and in 2010 they changed it to may establish along the Makai boundaries. Part B continues that along beach transit corridors where abutting landowners' human-induced, enhanced, or unmaintained vegetation interferes or encroaches with beach transit corridors, the Department of Land and Natural Resources may require the abutting landowners to remove the landowner's interfering or encroaching vegetation. So who provides lateral coastal access for fishing and gathering? Is it the state of Hawaii or the county of Kauai? HRS 115-7, state and county co-sponsorship of programs. The Department of Land and Natural Resources shall enter into agreements with the council of any county providing for the acquisition of public rights-of-way and public transit corridors pursuant to this chapter, provided that the county shall match the funds which have been appropriated by the legislature. The development and maintenance of the public rights-of-way and public transit corridors shall be the responsibility of the county. HRS 115-8, expending agency. This is a big one. The Department of Land and Natural Resources shall expend all sums appropriated for the purposes of this chapter and in accordance with Section 115-7. 115-7 was the state and county co-sponsorship of programs. So, the DLNR shall expend all sums appropriated for the purposes of this chapter. That's the $170,000 that the state legislature appropriated for the Alaloa Trail. Under HRS 115-8, they shall expend all sums. HRS 115-9, obstructing access to public property. A person commits the offense of obstructing access to public property if the person, by action or by having installed a physical impediment, intentionally prevents a member of the public from traversing a public right-of-way, a transit area, a public transit corridor, or a beach transit corridor, and thereby obstructs access to and along the sea, the shoreline, or any inland public recreational area. Physical impediments that may prevent traversing include but are not limited to the following: gates, fences, walls, constructed barriers, rubbish, security guards, guard dogs or animals, and a landowner's human-induced, enhanced, or unmaintained vegetation that interferes or encroaches with beach transit corridors. Obstructing access to public property is a misdemeanor, subject to fines of $1,000 for a second conviction, $2,000 for any conviction after a second conviction. HRS 115-10, the duty to maintain access within beach transit corridors. The Department of Land and Natural Resources shall maintain access within beach transit corridors under this chapter by requiring private property owners to ensure that beach transit corridors abutting their lands shall be kept passable and free from the landowner's human-induced, enhanced or unmaintained vegetation that interferes or encroaches with the beach transit corridors. That means you cannot put sprinklers on Naupaka and make them go down to the splash zone of the ocean. HRS 264-1, Highways Act. Public highways and trails. All roads, alleys, streets, ways, lanes, bikeways, bridges, and all other real property highway-related interests in the state, opened, laid out, subdivided, consolidated, and acquired and built by the government, are declared to be public highways. Public highways are of two types, state highways and county highways. Part B continues, all trails and other non-vehicular rights-of-way in the state declared to be public rights-of-way by the Highways Act of 1892, or opened, laid out, or built by the government or otherwise created or vested as non-vehicular public rights-of-way at any time thereafter or in the future, are declared to be public trails. A public trail is under the jurisdiction of the State Board of Land and Natural Resources unless it was created by or dedicated to a particular county, in which case it shall be under the jurisdiction of that county. The Highways Act continues that all public highways and trails once established shall continue until vacated, closed, abandoned, or discontinued by a resolution of the legislative body of the county wherein the county highway or trail lies. All state trails once established shall continue until lawfully disposed of pursuant to the requirements of Chapter 171. HRS 343-2, the cultural impact assessment requirement of the environmental assessment. Environmental assessments, environmental impact statements completed after April 6, 2000 must include an assessment of the impacts to the community cultural practices, together with measures proposed to minimize adverse effects and alternatives to the action and their environmental effects. CIA requirement applies to major developments proposed on conservation district lands or within a shoreline setback area, Waikiki Special District, any zoning that is being changed from agriculture, conservation, or preservation to a different use, or the use of state or county funds, subject to limited exceptions. So the use of county funds triggers the CIA requirement of an EA. HRS 171-26, the state is required to establish rights-of-way across public land to provide access to beaches, game management areas, public hunting areas, and forests. HRS 205A-2B to C, the Coastal Zone Management Act requires the state to protect and preserve historic, scenic, and open space resources, including which providing and managing public access to shoreline areas for recreational purposes. HRS 205A-2 Coastal Zone Management Program. The objectives are to provide coastal recreational opportunities to the public, historic resources to provide, protect, and restore historic and prehistoric resources in the coastal zone significant to Hawaiian and American history, protect scenic and open resources, protect and preserve and restore the quality of the coastal, scenic, and open space resources, and protect valuable coastal ecosystems, including reefs, from disruption and minimize adverse impacts on all coastal ecosystems. That's HRS 205A-2. HRS 205A-21 considers special management areas. The SMA lands, the legislature finds that special controls on development within an area along the shoreline are necessary to avoid permanent losses of valuable resources and the foreclosure of management options, and to ensure that adequate access by dedication or other means to publicly owned or used beaches, recreation areas, and natural reserves is provided. The legislature finds and declares it is the state policy to preserve, protect, and where possible to restore the natural resources of the coastal zone of Hawaii. HRS 264-1 A, B, and C. All roads, alleys, streets, ways, lanes, bikeways, bridges, and all other real property related interests in the state, open, laid out, subdivided, consolidated, and acquired and built by the government or built by private parties and dedicated or surrendered to public use, are public highways. Trails and other non-vehicular rights-of-way that satisfy the requirement of a public trail are also included. Ancient trail may become public if it was a public right-of-way at the time of the 1892 Highways Act was built by the government, or it became a public right-of-way subsequent to the passage of the 1892 Highways Act, or HRS 264-1B, 1988. HRS 6E-1, the Historic Properties Act. The Constitution of the State of Hawaii recognizes the value of conserving and developing the historic and cultural property within the state for the public good. The legislature declares that the historic and cultural heritage of the state is among its important assets, and that the rapid social and economic developments of the contemporary society threaten to destroy the remaining vestiges of this heritage. The legislature further declares that it is in the public interest to engage in a comprehensive program of historic preservation at all levels of government to promote the use and conservation of such property for the education, inspiration, pleasure, and enrichment of its citizens. The legislature further declares that it should be the public policy of this state to provide leadership in preserving, restoring, and maintaining historic and cultural property, and to assure that the administration of such historic and cultural property in a spirit of stewardship and trusteeship for future generations, and to conduct activities, plans, and programs in a manner consistent with the preservation and enhancement of historic and cultural property. So public trails are any trails that were in existence before 1848 is public. Anything on Ursula Emerson's 1833 map is public. Anything on a pre-1892 historic map is public. Registered map 1395 from 1878, all trails are public. So again, the public has a right of access to and along the beaches and shorelines in this state situated below the upper reaches of the wash of the waves. The counties have the primary authority to develop and maintain public access to and along the shorelines. The state's primary role in the shoreline area is to preserve and protect the resources and to support public access along and below the shoreline. In limited circumstances, the state, under its Na'alahele program, is responsible for the management and maintenance of public rights-of-way that are part of the Na'alahele trail system of ancient trails that are identified and established as public trails with documented and historic use and significance. Unlike other public rights-of-way that may exist by virtue of an easement, the Na'alahele trails are owned by the state and may lead to and from the shoreline and also provide lateral access along the shorelines. King Kamehameha III, Kauai, said, "Every little bit of land, even with a allodial title, if they were," meaning the Kanaka, "were cut off from all of the privileges, would be of very little value." After the Mahele, the Privy Council considered the rights of the tenants under the new system of private land ownership and proposed a resolution providing that the rights of the Maka'i Nana to firewood, timber for house, grass for thatching, key leaf, water for household purposes in said land, and the privilege of making salt and taking certain fish from the seas adjoining said lands shall be and is hereby sacredly reserved and confirmed to them for their private use should they need them, but not for sale. The king responded, however, by expressing his concern that even a little bit of land with a allodial title, if they were cut off from all other privileges, would be of very little value. Accordingly, the final resolution was passed with the comment that the proposition of the king, which he inserted as the 7th clause of the law, a rule for the claims of the common people to go to the mountains and the seas attached to their own particular lands exclusively, is agreed to in the Privy Council records 681, 687 from 1850. In 1853, the population had already diminished substantially, but it was still primarily coastal. There were many other trails on Kauai that were not coastal, like the Alaka'i Swamp Trail that was previously known as Kealawai Ohia, because it was made of ohia logs through the swamp, through the Alaka'i. In 1995, the Ripon decision stated that the government or the Konohiki cannot dispose of lands as to leave the Ho'a'ina destitute, indicating that the Mahele proclaimed Kamehameha's intention to share the lands with his people, and the confirmation of title was subject to inalienable sovereign prerogatives. Thus, the Land Commission's principles included appropriate provisions intended to preclude the Konohiki from disposing of the grassland to leave his Ho'a'inas destitute, and to preclude the government from selling unoccupied or vacant land as to leave the Ho'a'ina destitute. So public trails that were public at 1892, built by the government, are public in perpetuity. Everything on the 1878 map is public in perpetuity. The state has adopted the precautionary principle. In the Waiahole decision, they codified the 1992 Rio Declaration of Precautionary Principle, where there are threats of serious or irreversible damage. The lack of scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. That means if you don't got all the answers, you can't use not having all the answers as a reason for going ahead with it. The Pa'akai framework includes determining the identity and scope of valued cultural, historic, and natural resources in the project area, and the extent of the impacts to these traditional and customary practices, and the feasible action taken to reasonably protect these native Hawaiian rights. The state and all its agencies are obligated to protect the reasonable and traditionally exercised rights of Native Hawaiians to the extent feasible. The agencies are obligated to make an assessment, independent of the developer or applicant, of the impacts to these customary and traditional practices, and that must include the identity and scope of the valued historic, cultural, or natural resources and the impact to these traditional and customary practices, and the feasible action to protect these Native Hawaiian rights. This is known as the Pa'akai framework. The Hanapi case determined that reasonably exercised constitutionally protective Native Hawaiian rights qualify as a privilege in defending criminal trespass charges. To establish that conduct of criminal trespass is protected, a defendant must prove that they are Native Hawaiian, that the conduct is a customary and traditional practice, and that the property is less than fully developed. There were sovereign prerogatives for the common good of the public that could not be conveyed away, including the right to provide public thoroughfares and easements by means of roads, bridges, and streets. Kahuli'a'o Center for Excellence in Native Hawaiian Law has produced 4 excellent primers on traditional rights, water rights, iwi kupuna, and partition actions. They are available online, and you can also check them out hard copy from our libraries. This slide shows a listing of legal resources available. Here are some contact numbers for the County of Kauai, the Mayor's Office, and the Planning Director, and the Open Space Commission, some community groups that are interested in public access on trails in Hawaii. This slide shows State of Hawaii contact numbers and emails. This slide shows a listing of DLNR departments and divisions. This slide is a listing of Hawaii State DLNR divisions. The Naala Trail and Access System is enacted under HRS Chapter 189D and mandates that they must inventory and classify all existing trails located in the state, identify areas which have inadequate access, adopt rules to regulate the use of these trails and accesses, and to acquire additional trails and accesses in areas where there is inadequate access. HAR Section 13-130-18 prohibits interference like blocking trails and accesses, making physical changes to a trail that impede use, and threats against persons using trails or other forms of intimidation. This is a listing of environmental justice contacts, federal government contacts. Thank you for participating in this workshop and watching these videos. It's obvious that there is a wealth of historic trail maps and historic trail documentation, and that Hawaii is blessed with a wealth of trail law that stems from the Kingdom era, codified in Hawaii state statutes now. Ancient Hawaiian trails connect Na Kupuna to the keiki of the future and preserve the knowledge through the footprints. When Iolani Liholiho went to Europe as a young prince, he was asked how he knew so much about his people and his country and his culture at such a young age. And his answer was, Nevai ho'i ke ole o ke akamai. He alanui ma'a I ka hele ya o Maumakua. Who would not be wise on the path so long walked on by my ancestors?